Well, another one that I use in some of my talks to public safety officials, I teach at Georgia Tech sometimes, is a speeding case, 86 and a 65, 19-year-old college student going back to school. He had a .059, which is not a high reading, but it's still above the legal limit of .02 in our state, which is for underage. He also admitted to the officer on video that he smoked marijuana before he drove, and he had marijuana in his pocket. And in that particular case, my job was to take it piece by piece, and we did another bench trial, a non-jury trial, because I didn't think any jurors were going to be too amused by this young man's activities. And by the time I finished cross-examination, the only type of DUI that the officer thought he really had was being above the legal limit, because when he did the field test, he didn't find any signs of impairment, none of the usual signs that you see. And so he admitted that all those other cases really weren't supported by the evidence. But on the per se case, what he had done wrong is when it got to the portion of reading the person his rights, he didn't do it outside the car, which usually happens. He put him in the back seat, and then he turned his own audio off. He left the video running, but turned the audio off. My client took the stand and testified that he never read me my rights. The officer said he did, and the judge was put in the position of having to decide what to do. I convinced the judge that why would an officer with all this expensive equipment turn it off at the most critical time, and the judge, very upset about it, even said in open court, I don't want this pot-smoking, drinking, speeding teenager on the road with my wife and kids, but officer, you screwed up. It was your job to capture this evidence. You've got the burden of proof, and it makes me sick, but I have to find him not guilty. And he did. He found him not guilty, because that's what the law required that he do. He had a doubt about the case because my client took the stand. He said, yep, I smoked pot. Yep, I had marijuana in my pocket. Yep, I was drinking, and that alcohol level's probably right. And every question they asked him, he answered very truthfully, because it wasn't about impairment. It really wasn't about impairment. And I know how to break the cases down into what's important for each case.